Good morning and welcome to the Court of Appeals. We have two cases on the 9 o'clock docket. I assume counsel in Forfar versus Walmart are set up and ready to proceed.
Yes, Your Honor.
Yes, Your Honor.
In terms of our second case, Marchant versus Boulder Community, the clerk's office received an inquiry about using a demonstrative exhibit as a timeline. You don't need the court's permission to do that, but it will go a lot more smoothly if you can get opposing counsels to stipulate that it's accurate, because otherwise we're just going to take it as demonstrative and confirm it with the record. Okay, in Forfar, does either of you have any questions concerning our procedures?
None, Your Honor.
If any of our spectators has a cell phone or similar device, would you please turn it off so the lawyers are not interrupted? Otherwise, we're ready for oral argument in Forfar versus Walmart.
Good morning, Your Honors. My name is Mia Della Cava. I'm with the law firm of Cuttack Rock. My attorney registration is 39861, and I'm here on behalf of appellant Walmart Stores and the Walmart Stores related entities. Your Honors, this is a matter of first impression. This is an important case. There is a complexity to it, but at the end of the day, these are simple legal arguments, many cases in outside jurisdictions have succinctly answered this issue. The main issue in this case is whether the collateral source rule allows the recovery of medical expenses for which Mr. Forfar never incurred any obligation, expense, or liability, and to which his medical providers never had a claim against Mr. Forfar.
Let me ask you two preliminary questions.
Yes, Your Honor.
Are there any facts in dispute?
It is undisputed that Mr. Forfar's medical providers have failed to meet the requirements of the applicable regulations at issue. They have failed to file an affidavit with the Secretary of Health and Human Services.
Well, my question is a little broader. It's just yes or no. Are there any facts in dispute from your perspective?
No.
Okay. Second question. Are the decisions that you're asking us to make all de novo review?
Essentially, yes, Your
Okay.
Honor. The motion in limine is an abuse of discretion, but because it is a legal issue, it is essentially a de novo review.
Thank you.
Okay. So, as I was saying before, the medical expenses are illegal and unenforceable as a matter of federal statutes and regulations. Nonetheless, the district court has allowed Mr. Forfar to recover them against Walmart under the pre-verdict and post-verdict components of the collateral source rule. In allowing Mr. Forfar to recover such medical expenses as an item of damages in this case, the district court clearly erred and misconstrued the collateral source rule at the expense of federal statutes and regulations. Moreover, if the district court orders are allowed to stand, this will sanction Medicare fraud and totally undermine the intent of the applicable Medicare statutes and regulations. It will also allow the recovery of completely illusory damages as recognized by courts in numerous other jurisdictions. As I said earlier, Mr. Forfar is a Medicare beneficiary, and he received treatment under Part B of Medicare. Therefore, Mr. Forfar's physicians are covered by Part B of Medicare. Part B requires physicians to annually elect whether to be participating or non-participating physicians in Medicare. Regardless of the category, participating or non-participating, these physicians are subject to certain Medicare fee schedule. So these participating or non-participating physicians cannot just charge Medicare beneficiaries whatever they want.
Counsel, even if we assume that all of these regulatory Medicare laws, regulations, that they do apply, I still don't understand how that affects whether and when you would invoke the collateral source rule. Can you explain that?
Well,
assuming they apply, how does that affect?
the applicable statutes and regulations, they provide, if I can just lead into it very quickly, that a physician can opt out of Medicare, right? And then they can charge whatever they want pursuant to private contracts. But there are very strict requirements in this regard. So the physician must file an affidavit with the Secretary of Health and Human Services, and these private contracts must meet very specific disclosure requirements. And if these physicians fail to opt out adequately, then those contracts are null and void and unenforceable. So the medical expenses incurred pursuant to those private contracts, nobody has a claim to them. They are illegal medical expenses, and the contracts on which they are founded, the private contracts, are unenforceable as a matter of federal and Colorado law. So notwithstanding the unenforceability of these contracts, the district court invoked the collateral source rule to permit the recovery of these medical expenses. First, the district court denied Walmart's motion in limine, and then they also denied our post-trial reduction of damages under section 1321.111.6. So that's how the collateral source rule came in.
Is there, excuse me, is there a difference when a physician, well, let me state it differently. When there, a situation where there is a tortfeasor and a situation where there is not a tortfeasor, the regulations would seem to apply when there is not a tortfeasor, but here we have a tortfeasor, so then you have the question of the collateral source rule and whether Medicare falls within that rule. Is there a difference between those two scenarios?
I'm very sorry, Your Honor, but could you restate the question? I'm not sure that I'm following.
Okay. It seems to me there's two scenarios, one where there's a tortfeasor, one where there's not. And so the regulations you're talking about are when there is not a tortfeasor. But when there is a tortfeasor, then you get into whether there's a collateral source rule that covers this.
I believe the regulations are relevant to tortfeasors as well. If I'm answering, please let me know if I'm not answering your question adequately, and if I can explain why. The collateral source rule, there's two contracts at issue here. Number one is the pre-verdict component to the collateral source rule, and that is encompassed in section 10-1-135. That section provides the fact or amount of any collateral source payments or benefits shall not be admitted as evidence in any action against an alleged third-party tortfeasor. Similarly, the contract exception to section 13-21-111.6 provide that a verdict shall not be reduced by the amount by which such person, his estate, or his personal representative has been or will be wholly or partially, and this is the key language, indemnified or compensated by a benefit paid. So it is our contention that pursuant to these regulations, the excessive and illegal amount that is not permitted to be charged under these private contracts is not indemnification or compensation or a benefit paid. Those amounts simply extinguish by operation of law. And if you look at the Colorado Supreme Court cases on this point, most of them seem to assume that there is a pre-existing liability before the collateral source rule may be triggered. Your Honor, I hope that answers your question, and please let me know if it doesn't. So the regulations, yes, they do apply to these medical providers, but we are saying that because these medical providers were not permitted to charge these amounts are in fact illegal, that this is not a proper item of damages to trigger the collateral source rule.
How about the contract exception?
Same thing, and the key case on this issue, the contract exception, is specifically discussed in Volunteer of America Colorado Branch v. Garden Schwartz. In that case, the contract exception was construed, and the court construed that key language there, which is they examined whether the beneficiary received indemnification or compensation by a benefit paid. In that case, the plaintiff's healthcare providers billed $74,000 and Aetna satisfied the debts in full with a payment of $43,000. The court allowed the plaintiff to recover the higher amount of $74,000, recognizing that Colorado applies the collateral source rule to healthcare write-offs. The court's reasoning was that plaintiff would have incurred the full amount of those medical expenses but for his insurance contract with Aetna. Therefore, he was entitled to recover the higher amount. That is unlike the case here. The medical providers never, as an initial matter, had a claim to medical expenses in excess of the Medicare statutes. The contracts were void and unenforceable by the express language of the Code of Federal Regulations 405.405 and 405.430. Moreover, under federal statutes, they were not permitted to recover this amount from plaintiff, and the statutes also say, or anyone else. That would encompass a third-party tortfeasor such as Walmart.
Well, but, I mean, you cast the issue as the trial court let Mr. Forfar recover these illegal charges. Isn't it more accurate to say that the trial court allowed the jury to determine the reasonable value of medical services, and that's what the jury allowed to be recovered, although in an amount less than what Mr. Forfar sought to prove?
The jury did allow the reasonable amount. It is our contention that under the contract, under the pre-verdict component of the collateral source rule, which is encompassed in section 10.1.135, that the amount that is paid by Medicare is dispositive of the reasonable value of these medical expenses. Furthermore, it's not merely a jury question what the fact finder was allowed to determine, because the district court had the opportunity and declined to exercise it to reduce the verdict amount, citing the contract exception. And that was inappropriate because the excessive amount was not indemnification or compensation for a benefit paid. So for instance, if we go back to the Garden-Schwartz case, the Supreme Court held that the excessive amount, the write-off amount, plaintiff was indemnified for that amount by Aetna. That is not the situation in this case. Those amounts simply extinguished by operation of law. The medical providers never, as an initial matter, had a claim to those. Those contracts are inherently void. A number, and I'll wrap up here very quickly so that I can reserve the rest of my time. A number of outside jurisdictions have recognized that the collateral source rule, both pre and post-verdict, does not apply to Medicare. Based on my research, I have not found any cases which have specifically examined the regulations at issue here, which are 405.405 and 405.430. But several of these jurisdictions do apply the collateral source rule to provider write-offs, such as Delaware and West Virginia. Nonetheless, they held that they would not extend the collateral source rule to amounts written off under Medicare. The best example of this is in the Staten v. Delaware case, which was an opinion by the Delaware Supreme Court. In that case, Staten was billed $3.6 million, but Medicare satisfied the bill with a payment of $262,000, so the write-off amounted to $3.4 million. In that case, the court recognized that, yes, the court applies the collateral source rule generally to provider write-offs. But there, they recognized that the $3.4 million written off by Medicare was paid by no one. Any benefit that his healthcare providers conferred in writing off over 90% of their collective charges was conferred on federal taxpayers as a consequence of Medicare's purchasing power. In determining the reasonable value of medical services, the court treated the amount paid by Medicare as dispositive of the reasonable value of medical services. The trial court opinion in that case was also very instructive. The trial court characterized those write-offs as inflated and fictitious damages, which will run the risk of inflating other items of damages across the board. So as a matter of policy, I just wanted to point out that if the district court orders are allowed to stand, this will sanction and encourage Medicare fraud, and there will be essentially no teeth to the Code of Federal Regulations. And to the extent that this court finds that the collateral source rule nonetheless permits the recovery of these inflated and fictitious damages, then we would contend that the collateral source rule is preempted by federal statutes and regulations. And with that, I'd like to reserve the rest of my time.
Good afternoon, or morning. May it please the court, Judge Webb, Judge Fox, and Judge Marquez. The collateral source rule, or this case presents two questions, one on the pre-verdict collateral source rule and one on the post-verdict collateral source rule. Both have been recently decided by the Colorado Supreme Court, and Colorado Court of Appeals opinions have held against the defendant's position too. Their position comes strongly out of the dissents in the 2012 Colorado Supreme Court cases. I'm sorry, can you hear me? I wasn't talking into the mic. It comes out of the dissents, and their reliance on this Delaware case is misapplied. The Delaware case, in Delaware, there's no statutory collateral source rule, and there's no statutory pre-verdict collateral source rule. So neither portion of it is in their statutes. It's a common law adopted by the court, and so the court there is free to narrow it and widen it as it sees fit. But in Colorado, we have a statutory contract exception to the collateral source rule. That's statutory, and then we have the 10.1135 paragraph 10A that codifies the evidentiary component, and those aren't flexible like the Supreme Court rewriting its own precedent. And here, this court is bound by Colorado Supreme Court precedent, but there's also lots of compelling Colorado Court of Appeals precedent, including a case that we didn't cite in our brief, but CTLA cited in their brief. That is the Department of Human Services case, and that involves PIRA, and I think it's 2016. I don't have the site handy, but it's in the CTLA brief. And in that case, the court applied the collateral source rule to PIRA benefits, disability benefits, and people that have PIRA don't have Medicare. So it's similar. Here, the defense in their opening brief, and I would argue even in the reply brief, don't really address the biggest issue in their case, and that is the Medicare secondary payer statute. The statutes that they're relying on, if you looked at like a Venn diagram, you'd have a big circle, and that's all of Medicare statutes. And if you want to opt out, if you're a treater and you want to opt out of that big circle, you have to go through the steps that defense points out. But then you have this other circle over here, and that's people that are injured by a tortfeasor. And that circle could easily intersect with health insurance over here, or with something, with PIRA over here. But with Medicare, when it intersects, you have this portion in the middle, and that's where the Medicare secondary payer statute applies, and that's why it's narrower than the broader part, and that's why it's in the exceptions portion of the statutory scheme. The secondary payer statute is construed by Medicare in the the MSP manual to allow providers to bill over the Medicare amount when there's a tortfeasor that is self-insured like Walmart is. And that's undisputed, that they're self-insured, so it applies to them. And when that happens, then the treater can bill Medicare after 120 days, which is called the promptly period. They're required to try to pursue, if they want to do that, they're required to try to pursue payment from the tortfeasor's insurance first. But it's a may bill language, and so they don't have to bill Medicare. And instead, like the treaters do here, similar to, like the treaters do here, they have liens. Defense in closing argument, here they're saying, it appears they're saying that there's no value to the medical care that my client had because there's these null and void contracts. And we don't agree that the contracts are null and void, but the defense presented those at trial, and in their closing argument, they argued that these doctors are treating on a lien contract, and that they get a percentage of whatever comes out of the verdict. And so they're admitting that there's value to the medical treatment, but that shouldn't be a question anyway.
Counsel, your opponent contends that the federal law preempts the collateral source rule that we have here in the state of Colorado. What's your response to that, and was that raised before the trial court?
So, and was that raised? I'm sorry.
Before the trial court, was the preemption issue?
Was our answer raised, or was their position?
Their
Their
contention?
position was raised. Their position made some arguments that are in the statement decision from Delaware about the Affordable Care Act, which maybe wisely they took out in their appellate brief, because that portion of the Affordable Care Act, the individual mandate, has been repealed. So that portion of the state, and it's a central portion of that decision, is now out the window. Boy, I lost track of the question.
Just give us your client's response to the preemption argument.
Yeah, so, the preemption argument, I mean, the 10th Circuit in Berg held that Medicare comes under the collateral source rule. In Kinningham, the panel of this court found that Medicaid comes under it, and I think Kinningham is cited in the, it has a 2013 case, and it's cited in the Department of Human Services case. The preemption argument doesn't, it's not developed in their brief. I mean, in our answer brief, we laid out some of the law on preemption, but that's not laid out in their brief. And I think there's a reason, because it's not a very good argument. There's federal law and state law often, sit together. They're not always at heads. And, the holdings from the U.S. Supreme Court say that are cited in the brief. There's not a preemption when a portion of the Medicare statute allows this billing and allows them not to pursue it from Medicare. If they pursue it from Medicare, they can only recover from Medicare the portion of that Medicare would pay in a conditional payment that then would have to be paid back. But they don't have to do that, and instead, they can bill at their regular rate, and that is, the secondary payer statute was passed in 1980 in an omnibus bill that by Congress. For 15 years, this is in some of the cases, but for 15 years, the Medicare Trust Fund had been a primary payer. And state statutes were saying, and insurance companies were saying, that the insurance company could be the secondary payer. And so when they passed this Medicare secondary payer statute, what they said was Medicare is always, the Medicare Trust Fund, tax money, public money, is always the secondary payer if there's a primary payer. And so they made Walmart as a self-insurer a primary payer. So they're always secondary to the secondary payer statute. And that is why, into Medicare, and that's why, treatment providers don't have to bill Medicare, and they can bill over the amount. It's an encouragement. Also, under the Chevron doctrine, which Colorado has adopted, I don't have the full site for Chevron, but I think everybody knows what the Chevron doctrine is. The Medicare as an agency has construed the statute and provided its regulations, and then in the manual, the MSP manual, they further construed it. And in Smith v. Farmers, and in the Wainscott case, which is from a panel of this court, there's a good discussion of the Medicare secondary payer statute and how the court has to defer under the Chevron doctrine to that construction.
Thank you.
Even accepting your interpretation of the MSP manual, is it correct to say that the providers might bill Medicare, or the trust fund, in excess of the limits, but they could not go against the patient?
So no, if if I'm hearing you correctly, the providers, I mean, I guess they could send a bill for $1 million for something that Medicare would only pay $10, but then, you know, they would only get paid $10. But I'm not positive they could send a bill over the amount, but there's an agreed upon, or not agreed upon amount, impressed upon amount by Medicare to what they could bill Medicare for. But they could still have a lien contract with, you know, the injured party, because the injured party under the collateral source rule can still recover more than the Medicare amount.
Does the,
Did I answer that?
not really, but it was probably a poor question. Does the MSP manual specifically address lien contracts?
Specifically address lien contracts? No, it doesn't say lien contracts. It does say, as we indicated in our brief and in Wainscott and in Smith v. Farmers, that that it says that providers can bill over the amount.
But bill who? The patient or ultimately the trust
Ultimately,
fund?
the self-insured party. Or they can have, you know, and then there's in there about, there's a portion in there, and I think in the regs, about that talks about settlements and judgments in the secondary payer statute or regs. And, you know, you have, if Medicare has made a payment, Medicare has, you know, subrogation rights to keep that Medicare trust fund as whole as possible. But, you know, the encouragement is to seek the outside source. And then Medicare is treated like health insurance and you know, any other, you know, type of contract exception. And, you know, one of the cases in the briefs that wasn't addressed in the opening brief, it's the Barnett case, says that Social Security disability insurance comes under the collateral source rule. And that's important because Medicare here, I mean, if you look at the post-trial motion in this case, you know, they had a hearing, they had extra briefing, and the judge found that our client had earned and worked the appropriate amount of quarters to qualify for Social Security, and because of his disability, had Social Security disability, and under Social Security disability is where you find the Medicare. And so, you know, although Barnett doesn't say the word Medicare, the umbrella over Medicare is the Social Security disability, and that's how he gets to Medicare, and that's how, I mean, so it falls right within that, and that's why that case is controlling. Did that help, or did I go off on a tangent?
Well, let me try one more time. Your opponent says that charges in excess of the Medicare caps are extinguished as a matter of law, and therefore Mr. Forfar could never be liable.
Okay.
All right. Now, it seems to me arguably that's different from a contract that an HMO may enter into with a hospital that says, you know, you serve our members, you take 40 cents on the dollar. You know, I suppose if the HMO went bankrupt, the healthcare provider could go back against the patient for 100 cents on the dollar. Your opponent says that scenario can't happen under Medicare. The excess charges are just gone. Do you agree with that or not?
I don't, and I think that gets back to what I was trying to say with like kind of the Venn diagram. I mean, in the middle where you have the secondary payer statute applying, the narrower portion of the statute is going to control, and it allows billing over that amount. And so
Okay,
if the bill was just in Medicare, then yes.
Okay, but excuse me, you say it allows billing, but to whom? Can amounts in excess
to the
of the
self-insured.
caps be billed to the patient, or only to Medicare if the tortfeasor doesn't stand up?
I guess, you know, it's billed to the patient, but, you know, for the patient's care. But, I mean, you know, so if it was my bill, it would say my name on it. But if I'm injured by a tortfeasor, it's going to the tortfeasor to get paid. You know, they can bill over the amount to their regular charges.
But they can't collect over the amount from the patient, correct?
They can, from the judgment, they can collect their full amount.
No, from the patient. Can they collect above the caps from the patient.
Not without a tortfeasor involved. And if they do this system and, say our client had lost, then no. If they never billed Medicare, and maybe they're too late, I don't know about the timing on billing Medicare, but then it's extinguished. But when you have a judgment that awards the money, then, they can get, their full amount under the lien.
Okay.
And I don't believe I have anything else to say. Does the court have any other questions? Thanks.
Thank you, Your Honors. I will speak quickly since I have very limited time left. I would just, as an initial matter, like to point out that this doesn't merely involve Medicare caps. These are illegal private contracts, unlike many of the cases cited. Secondly, the cases that Mr. Boyle cited are distinguishable. They are old cases. They were issued long before the enactment of the regulations at issue. 405.405 and 405.430 were adopted and made final in 1998 and apply to private contracts made after 1999. Therefore, Barnett and Berg do not apply. Third, I'd like to talk about the MSP statute. None of the cases in outside jurisdictions that have analyzed this issue have ever even cited the MSP statute to allow the recovery of these illegal damages. And additionally, they pointed out in their answer brief that it's not the MSP statute here that applies. That is not directly applicable. What they're really relying on is the Smith v. Farmers decision and Code of Federal Regulations 411.35, which is cited in the Smith v. Farmers decision. If this court believes that Section 411.35 potentially allows Mr. Forfar to recover the excessive medical expenses, then it should apply several rules of statutory construction. Number one, specific provisions prevail over general, and number two, the most recently enacted Code of Federal Regulations applies. I would contend that the private contracts provisions are more applicable to illegal private contracts than the MSP regulations. And number two, the 405.405 and 405.430 were more recently enacted. And that's the rest of my time.
We appreciate the arguments of both counsel. Counsel are excused. The case stands submitted. We will issue a written opinion in due course. When the tables are cleared, we'll take up argument in Marchant versus Boulder Community. We're ready to proceed whenever you are. Did the timeline demonstrative?
I decided that the record has it adequate.
Okay, enough said.
Thank you, though. May it please the court. My name is Tom Russell. I represent Mrs. Marchant, who is the natural mother and guardian of Krista Marchant, who was injured and whose treatment is the subject of this case. Let me say, Judge Webb, I don't believe that we have any factual issues that are in dispute. Perhaps we have a little bit of a dispute as to when the Boulder Community Hospital actually bills Blue Cross, and maybe if, whether that happens in February or March, but I don't think that that has a lot, that is not tied to that much. Our issues are de novo. We have a new statute that has not been interpreted by this court or any of the other appellate courts. So I think that's where we are. Mrs. Marchant's daughter was injured, treated at Boulder Community Hospital. Their charge master rates, the rack rates at the hospital, the MSRP, if you will, they issued a bill for a little more than $27,000, a little under $28,000. And rather than bill Blue Cross Blue Shield for something under $8,000, they filed a hospital lien against her. And that's the issue here. That's in conflict, we argue, with the 2015 amendments to the Hospital Lien Act, which require that the hospitals first bill insurance when somebody comes in with insurance. That was the legislative goal, and we think that overreaching is not something that the statute permits.
Okay, from your perspective, what happened before the lawsuit was filed? In other words, did they bill Medicare? Was the lien reduced?
First, there's one lien filed, a lien that we regard as invalid. Then there's an amendment to that lien that continues that lien. That's not a new lien, but that continues that lien, that amends it and adds a little bit of information. It added the name of the tortfeasor to that. Then there's a period where Mrs. Marchant says, hey, I have health insurance, withdraw this lien. They receive that information, and eventually they reduce the bill to the amount that Ms. Marchant would have owed, that Ms. Krista Marchant would have owed, had Blue Cross Blue Shield been billed.
This is the $775.
Yeah, down to that smaller amount later. And then Ms. Marchant, anxious about her daughter's credit situation and calls from the hospital, pays that. Let's see. It's reduced to that amount. The lawsuit is filed. Then after the lawsuit is filed, Ms. Marchant pays that, and the lawsuit and the lien is terminated with a filing with the Secretary of State. So
I'm sorry, go ahead.
Is there a question as to when the hospital found out that your client was insured?
There's no question about that, Judge Marquez. In their answer, they admit that they knew that she had insurance when she came in, and I pleaded that they had billed her health insurance many times before because she was a patient of that hospital in the system. So they knew her. She was a sort of patient who would come in, and they'd bill the insurance routinely. So there's no question that they knew that she was insured. Further, on page 314 of the record, you see that when she came in, you can see that Boulder Community Hospital has a little code in the file that's called an insurance reorder. And what they do is they take her Blue Cross Blue Shield and make it secondary, and in the primary position, they put GEICO, the liability policy.
Okay, going back to my question. Then.
Yes.
As of the filing of the lawsuit, the lien is for $775.
The dollar amount of the lien at that point is for $777, yes.
And Mrs. Marchant or her daughter owed that because Blue Cross paid a slightly reduced amount of the bill, correct?
I can't absolutely say that they paid, but I know that under the contractual rates, that is the amount that would be the patient responsibility there.
Okay. If the only lien ever filed had been the $775, would you have a claim?
I believe I would, actually, and because the statute also specifies that the hospital must treat people injured due to the negligence of other people in the same way that they treat other patients not so injured. And the hospital does not routinely file hospital liens against people who just come in for some sort of medical treatment and owe $500 or $1,000 or whatever. So I think that part of it.
Wouldn't that be a factual dispute that's not appropriate for us to get into?
Not for, I mean, I don't think it affects this, but it might, yeah.
Okay, go on.
Okay. So there's no right to cure. The hospital's argument rests on two things. One is a right to cure, right? There's no right. I like to think of it in terms of first the bank robbery cases where you take the bags of money, you go out the door, and the police happen to be standing there, and you hand them the bags of money. You've still robbed the bank. People Against Pedri is one of those from 1986. People Against Marquez different Marquez. 1974 might be another one of those cases, and there's some others. There's only one narrow safe harbor in the statute, and that allows for, essentially for the situation, Judge Marquez, where somebody comes in, say, and is unconscious, and you don't know if they have insurance or not. You go ahead and treat them, file a lien, and then the next day their parents or their husband or wife or somebody comes in with the card and says, hey, by the way, we have insurance. That's the safe harbor of subsection 3. And as I argue in the briefing, I think that Grandote points out that when there's a safe harbor or provision like that in the statute, that suggests that the legislature intended that to be the sole safe harbor, right? And that safe harbor doesn't apply here, and Boulder Community Hospital has admitted that in the briefing, that doesn't apply because, of course, they knew there was insurance when they came in. We might compare mechanics liens here. The mechanics lien statute, for example, in Section 109, subsection 6, has a right to cure built into the statute, right? And I actually encountered this when I was reading Judge Fox's opinion in SureShock, which seems to me to be a terrible name for an electrical business, if I do say so, SureShock. But there's a specific part of the mechanics lien statute that says you can cure, you have to do it within the time allotted to do some other things, 2 and 4 month periods. There's no such provision, and had the legislature intended for there to be such a provision, they would have written that in. They wrote one in for people who come in and you don't know if they have insurance and you want them to get treatment. They didn't write another one in that says, if you bill somebody with insurance knowing they have insurance, you can later fix that. The second part of their argument is that amendments create separate liens. There's no support for that. I had the misfortune of having to read the Statutory Registration Act, the Electronic Statutory Registration Act, which hasn't been adjudicated at all. But since 2012, both that act and the Secretary of State's site make clear, the Secretary of State makes it clear in nice language. Since 2012, the amendment of a lien doesn't create a new lien, but is just a continuation. And you see that in the regulations, you see that in the statute, you see that in the Secretary of State's site, and you also see it in the exhibits that I've filed where when they amend the statute, you'll see the master document number, and then you'll say this amendment is a continuation. So we file the first lien, amend it, that continues it, amend it again, that continues it, and then the final amendment of it is actually a termination.
Counsel, it makes a lot of sense to me that if a lien is filed that is in excess of what is owed, that there should be a remedy. But I just don't understand what the harm is once there is a lien for the correct amount. Like, what's the harm to the person against whom the lien is filed? And why would the legislature, I mean, I could see the legislature wanting to fix the situation where the lien exceeds what's owed, but why would it want to create a remedy when the lien is for the amount owed? You indicated that your client paid, or the mother paid.
She eventually paid. I mean, it's a standing issue, really. And first, there's legislative standing because the legislature has said that this is an issue that they want to deal with, and that they're concerned with this overreaching that has been going on, that people have been denied the benefits of their health insurance when, in fact, they show up at the hospital treats them, charges them the rack rates, and doesn't use their health insurance. So that's part of it. In this particular case, and in the exhibits I show, that Mrs. Marchant's settlement with GEICO is held up because of this lien. GEICO specifically writes and says, we have a minimal policy here of $25,000. There's a $27,700 lien, and so we can't settle it. We're prepared to pay policy limits here, but we can't do that. And so that delay is actual damage. We're actual damage required here, right? A third point is when you have a hospital lien filed against you, I can find it. I just search the Secretary of State's site and I find it. And just sort of getting all of this. I mean, there's some, in Wainscott, for example, there's a citation that they say you have standing simply because of the filing of the lien, and citing, I think, a Kansas case there as well. So the legislature was concerned about it and concerned enough about it to enact this statute, and a pretty clear statute to say, and I think say no right to cure, right? Amendments don't form separate liens, and again, I think in Sureshock, that would have created a nuisance there, because in Sureshock, one of the parties was arguing that an amendment required a new notice of a lien, and had they made this same argument, then you would not have been able, well, you would have had to rule against them, is what I think. Finally, let's talk about the language "is subject" in here. When we interpret statutes, we rely on the text, and we rely on the text with regard to the legislative purpose. And here the legislative purpose is to, as I've described, is to get insurers to bill to get them to bill health insurance, right?
Isn't it a correct statement of the law of statutory interpretation that legislative intent cannot override plain language unless it would produce an absurd result?
We're close to that, I think, but
Well,
not
is my statement,
your statement is correct, that it
Okay.
can, unless it would absurd, but it is also the case that a purposive interpretation is one that should read the language in light of the purpose, and that we should favor an interpretation of the words that is consistent with the purpose rather than one that undoes the purpose of the statute.
doesn't that assume that the words are ambiguous and therefore could be interpreted different ways?
If we get to that, and if we get to ambiguity, if we actually get to ambiguity, then I think we can get to the legislative history that I included in the briefing.
What's ambiguous about, quote, "who is subject to a lien," unquote?
I think "who is subject to a lien" means when a lien is filed, when it's perfected, then someone is subject to the lien. And "is subject" means is subject now or is subject in the future, because of course it includes the future tense, right? I think
Could the
is,
legislature have said who is subjected to a lien?
if they, it might have been, my life might have been a little easier had they said that, but I don't think that this is either a sort of linguistic change that undoes the purpose of the statute. That I think "is subject" means when it's filed against you, you're a subject, or it's synonymous with against whom a lien is filed, and that's used in sections 103 and 104 of the statute. In contrast with Sifton, there's no tie to a point in time, that the statute in Sifton, which you dealt with in the spurious lien documents case, says if at this point in time the lien is determined to be this, then there's no tie there. I would say that the argument that Boulder Community Hospital makes guts the statute by taking the first words of the amendment, "before a lien is created," and essentially turning them into "before a lawsuit is filed." And that's not what the legislature intended. I'd like to reserve the remainder of my time, Your Honors. Thank you.
May it please the court, counsel. Alan Epstein on behalf of Boulder Community Health and Cardin Outreach. CRS 3827-101 subsection 7 provides that an injured person who is subject to a lien in violation of this section may bring an action in a district court to recover 2 times the amount of the lien attempted to be asserted. The issue in this case is whether the statute must be applied as written in the present tense. Since plaintiff was not subject to a lien in violation of the statute at the time she filed her complaint, the statute does not apply. The language of the statute...
The statute doesn't say "is subject to a lien" at the time she filed a complaint. It says "is subject to a lien, may file a complaint."
But she was not subject to a lien at the time she filed her complaint.
Well, true, but, well, you can argue that, but she was initially, and the argument seems to be, is if you're subject to a lien at any time, you can file a complaint.
But that's not how the courts have interpreted that language. It's subject to. And I'd refer the court to, although the wording of the statute was somewhat different in Sifton v. Stewart Title Guarantee, this court addressed a similarly worded provision in the spurious liens and document statute, and the court reasoned that because the temporal wording of the statutory language was couched in the present tense, the plaintiff could not recover attorney fees in that case because the defendant had released the offending lien before a show cause order hearing was conducted. The court, I would argue that if not on all fours, Sifton is close to being on all fours. And in Sifton, the court focused on the temporal word is, which is the same operative word in the hospital lien statute at issue here. Counsel argues that the language, his world would be easier, or the language might have been better couched had it, but that this language is a slight technical grammar error. Well, it's not an error unless the legislature didn't mean what it said, or that it is language which can be interpreted as ambiguous, and I do not believe that this language is ambiguous. And although the precise statutory phrase is subject to, does not appear to have been addressed in a Colorado appellate decision, it has been addressed in other jurisdictions. Those courts which have addressed this issue in cases such as Reynolds v. State, a Texas Court of Appeals decision cited in defendant's answer brief, these courts have held that that phrase applies in the present tense, not the present and past tense, as plaintiff advocates here. And plaintiff advances several public policy arguments as to why the plain language of the statute should be rewritten to say something that it does not, such as who is subjected to or who has been subjected to. But if the General Assembly had intended to write the statute like that, it would have done so. And when the legislature enacts a statute, the court presumes that the legislature is aware of existing case law precedent. When the legislature here enacted this statute, therefore, it was aware of case law precedent such as Sifton and People v. Perry and In re ATM, which are cases cited in defendant's answer brief, where this court held that present tense language in a statute must be enforced as written. Counsel argues that, defendant argues that there's a right to cure. Defendant's not arguing that there's a right to cure. Defendants are relying solely on the wording of the statute, which means that they didn't need to cure because at the time that plaintiff filed her complaint, there was no offending lien. And if the legislature did not or no longer intends this result, then as this court held in Sifton, plaintiff's policy arguments are better addressed to the General Assembly. And plaintiff's arguments are generally policy arguments as to why the phrase is subject to should be rewritten to say something else. Plaintiff also argued in her reply brief that permitting a hospital to release a lien before an injured person brings an action would promote races to the courthouse. But the same could be said for the statutory language that this court addressed in Sifton, and that did not deter the court from enforcing the statute as written. And this is also a policy argument, which again is an argument better addressed to the General Assembly. And unless the court has further questions, defendants request that this court affirm the trial court's entry of summary judgment in their favor. Thank you.
Your Honors, with regard to the spurious lien document statute, Judge Webb issued that ruling, but the statute says if, following the hearing on the order to show cause, the court determines that the lien or document is spurious. So there's a specific temporal pointer in there, but more importantly, I think, that statute, which predated my arrival in Colorado, I arrived in 2000, but I understand that people were filing liens against judges and prosecutors and the like that had no basis whatsoever. And the goal of that statute is simply to blow those out of just get those off the record so judges and such can sell their houses, that's the goal. The goal with regard to the hospital lien statute is a different one. It's to stop hospitals from refusing to bill insurance, instead trying to use their rack rates. And it is to back that up with some enforcement by the plaintiffs. So there are different goals, And those goals are expressed in the text of the statute. And I think that the statutes, of course, have to be read in terms of those different times, or in terms of those different goals, that's how to look at those. So the position in time, as I said, but maybe hurried through what that is subject means. I believe that is subject is related to that we want to achieve a harmonious reading of the entire statute. So, for example, in section 102 of the statute, such lien shall take effect is essentially synonymous with is subject. In 103, we say there's a reference to an injured person against whom there is a lien. That is to say, someone who is subject to a lien. And you see the same thing in 104. You see any person notified of such lien. That's someone who's subject to a lien too. So I think a consistent, harmonious reading of the statute is that is subject means someone who is subject to a lien from the time of their treatment forward, is subject now or is subject in the future because the present tense incorporates. I'd like to thank your honors and ask that you rule in favor of the appellant here. Thank you very
We
much.
appreciate the arguments of counsel. The case stands submitted. Counsel in this case are excused. We will issue a written opinion in due course. We have 2 workers' compensation cases on our 10 o'clock docket. When the tables are cleared, counsel in the Schwan home case may set up, and I will poll my colleagues to see if we're going to take a short recess. We will not take a short recess, so when council are ready to proceed in Schwan's home, we're ready to listen. Council, whenever you're ready.
Good morning. May it please the court. My name is Jackie Condon, registration number 47348, from the law firm Pollard Miller on behalf of respondents, Schwan's Home Service Incorporated and the Hartford Insurance Company. Your Honors, before us today is a question of whether or not the Industrial Claims Appeals Office decision affirming Administrative Law Judge Spencer's ruling that issue preclusion did not apply in the case is the first part of the question. The second part, which is not as important, I'll be touching on it briefly, but I really want to hit home on this first part because I believe procedurally, historically, that the court has been misapplying the issue preclusion as it pertains to workers' compensation matters specifically and not utilizing properly the standard which has been determined and interpreted as burden of proof. The second is whether or not there was substantial evidence to support the decision by ALJ Walsh. The question of issue preclusion as it pertains to workers' compensation matters has been applied based upon the case of Sunny Acres. In this matter, we had a case where the claimant was alleging he had CRPS, a diagnosis that was not fully ruled out, not fully determined by his authorized treating provider. That matter of whether or not he had CRPS went to a merits judge. It was litigated. The judge heard testimony from the claimant's physician, from the IME physician for respondents, and ultimately, after final adjudication of that issue, it was denied and dismissed. The claimant was then going through a 24-month division IME, which procedurally occurs when a claimant has not yet been placed at maximum medical improvement by the treating provider. There is another medical opinion of maximum medical improvement, and a party can apply, respondents can apply for a division IME to address whether or not the claimant is in fact at maximum medical improvement, and if so, what is the permanent impairment rating. In this matter, the division IME indicated that the claimant was not at maximum medical improvement and required further testing to determine, possibly rule out or determine whether there was the presence of CRPS. Respondents challenged that division IME opinion at a hearing, arguing that issue preclusion applied. It had gone before a merits judge. The question of whether the claimant had CRPS was fully adjudicated, litigated, appealed to the Industrial Claims Appeals Office. The order from the judge finding the denial and dismissal of the claim for CRPS was affirmed, and there was no further appeal. So that case was fully litigated and final on the issue of causality for CRPS.
Okay. Approximately how much time lapsed between the medical evaluations that were litigated in the first case and the dime physician's exam that was litigated in the second case?
There was approximately 1 year.
All right. You know, I'm going to suggest a simple answer, which usually isn't a good idea, but why isn't it possible that the claimant didn't have CRPS, at least to a medical certainty, a year ago, and when the dime physician examined him, he did have CRPS? So you've got essentially different snapshots in time at which physicians come to different conclusions.
Right, and I understand that position. However, the claimant's presentation specifically in this case was substantially similar. There was no change in his condition. He was ambulating with a crutch originally. He had a crutch at the second hearing. He had atrophy due to disuse, and all of the factors that were considered for applying and finding CRPS by the judge at the first hearing were still present or unchanged at the second hearing. The dime physician didn't say, oh, I see that this condition is worsened and he's changed. It just says, I'm not sure if he has CRPS, despite the fact that the original judge considered the medical treatment guidelines, applied all of the factors that have to be met under the medical treatment guidelines for a consistent diagnosis of CRPS, and ruled it out. He just said, I think we should do some more testing. There was no change in condition for the claimant. There was no presentation of any new medical evidence at that subsequent hearing. It was just the four corners of the paper from the division IME physician that were considered by the judge.
Well, did the dime physician say that nothing has changed from the, I mean, he wouldn't even know what the presentation was at the earlier exams, would he?
Correct, but he had the medical records that documented his physical condition at the time when the original determination was made that there was no CRPS, as well as medical examinations made in the interim.
Okay, well, so did the dime physician say nothing has changed, but I'm still going to come up with a different conclusion? Or did he say I'm coming up with a different conclusion?
He did not say nothing had changed. What he said is he continues to have complaints of pain disproportionate to his findings, which would be an indication of CRPS. So he was acknowledging there was a continuation of the same condition and no real diagnosis from a physician that could explain it other than the fact that he may have CRPS. So he did not find that there was a significant change in condition that warranted revisiting whether or not he now had CRPS, conceding that before it was unlikely that he had it based upon his presentation. It was just the ongoing complaints of pain, which is one of the factors of CRPS, that are disproportionate to the physical examination findings. And again, that's just one of the many factors of findings that can be considered for CRPS. So, may I proceed?
Yeah, absolutely.
Okay. So when the division IME physician examines him and finds that there needs to be additional diagnostic testing, respondents challenge that opinion. They take it before the judge, and the judge determined that issue preclusion did not apply because at the lower hearing, the question of causality was based upon substantial evidence, preponderance of the evidence standard for burden of proof. The burden of proof to overcome a division IME is clear and convincing evidence.
It's also on a different party.
So, apologies?
The burden is also on a different party, correct?
Correct. It's whatever party is challenging. So in this case, it was incumbent upon respondents to overcome the division IME, whereas originally it's the burden upon the claimant to prove entitlement to medical treatment for causality. However, none of the courts indicate that there's a concern about which party bears the burden of proof when determining issue preclusion. All they determine is whether or not both parties were present, whether the issue was previously decided, and whether they had a full and fair opportunity to litigate that issue. So the question before ALJ Spencer at the subsequent hearing about whether or not the claimant had, whether or not respondents overcame the division IME on CRPS should have been limited to essentially a causality determination. And there is no law that says specifically it has to be the burden of proof. The courts have repeatedly misinterpreted Sunnyside, which is the overarching case that says issue preclusion applies to workers' compensation claims. If you look at the matter, Sunny Acres. If you look at the matter in Sunny Acres, they say it's whether or not the parties had the same incentive to vigorously defend themselves in the previous action. Sunny Acres came about because there was a claim for temporary disability benefits. Following that, there was a claim for permanent total disability benefits. They don't reference that there's a different standard or burden of proof for entitlement to those benefits. Temporary disability benefits occur when you miss time from work as a result of your work injury, and therefore you get periodic indemnity benefits. Permanent total disability benefits, the claimant is saying, I am incapable of working for the rest of my life because of this work injury, so therefore I am entitled to indemnity benefits for the remainder of my life. Obviously, the entitlement and the exposure for the client is different. They never address whether the burden of proof has to be the same. And to the contrary, Sunny Acres actually, when applying issue preclusion to workers' compensation matters, says they have referred to family law matters and says, recognizing that even though standards of proof and findings in care and protection proceedings are identical to those in subsequent consent to adoption proceedings, collateral estoppel is inapplicable because of the incentive to litigate. So the burden of proof is not what governs and controls, and it's repeatedly been interpreted that that's how it should be applied. But it's not the burden of proof, it's the incentive to litigate. Otherwise, there would be no purpose to having a hearing before an administrative law judge to determine an issue on the merits as the trier of fact if it can be overcome by a medical opinion.
Okay. Is it your position that considering differing burdens of proof as a litmus test for applying collateral estoppel is wrong in general? And I will tell you that a lot of federal circuits have said it isn't wrong. Or are you saying it is maybe a generally acceptable principle but should not be applied to workers' comp? And if so, it should not be applied to workers' comp because?
I believe specifically, I can't speak to other areas of law. I don't practice in those other areas of law, so I'm not sure what the implications would be on those. But I know for certain in workers' compensation, that is not the correct test. It's not consistent with the overall goal of workers' compensation, which, if you read the Workers' Compensation Act, is to assure the quick and efficient delivery of disability and medical benefits to an injured worker at a reasonable cost to employers without the necessity of any litigation.
So, okay, so it's your position that the differing burden of proof component of applying issue preclusion should not be part of a workers' comp analysis?
I believe that it's not consistent with the law, with the case law, that it should be. I believe that the litmus test is the intent and the incentive to vigorously litigate, and that's not the same as the burden of proof. I believe it's been misapplied and misinterpreted that it's the burden of proof that governs, but in fact, what should govern is the incentive to litigate. The exposure at the hearing on causality was identical to the exposure at the hearing for the division IME, overcoming the division IME. The claimant's physician conceded during the testimony for causality that, yes, if there is no diagnosis of CRPS, my client is at my patient is at maximum medical improvement. So at that point, that was an identical exposure, where the division IME, the question is maximum medical improvement. And now it's piggybacking and giving a second chance to litigate causality that's already been determined completely undermines the authority of the judge and the judicial system and the purpose of issue preclusion, which is finality of adjudication.
All right, I'm sorry, I lost a little bit of focus there. So is your argument unique to workers' comp? And if so, why? Or is your argument broader that incentive to litigate simply should trump differing burdens of proof in any context?
Well, I believe in reading from Sunny Acres that other areas of law would also agree that the incentive to litigate is the overarching litmus test, not the burden of proof. Because as I indicated before, for example, in care and protection proceedings versus consent to adoption, they are the same burden, they are the exact same burden of proof. but that's been determined that that is not what the litmus test is for issue preclusion. It's the degree of finality of a proceeding. So it would be speculative to say across the board, the burden of proof trumps no matter what. You have to look at the facts and consider what was the incentive to litigate. And if there was the same incentive to litigate at the original hearing in this case as it is the subsequent, then you are relitigating an identical issue. And that's the purpose of issue preclusion. The law, as it's stated as the 4 prongs of issue preclusion, doesn't say burden of proof. It says that they have to be identical issues of fact to be considered. So the issue sought to be precluded is identical to an issue actually determined in the prior proceeding. Against who they sought, they were privy to the proceeding, a final judgment on the merits, and the party against whom the doctrine is asserted had a full and fair opportunity to litigate the issue. So nowhere in there does it say the burden of proof must be the same. And the court has further interpreted in other areas of law outside of workers' compensation, as I just indicated, that it's the exposure and the finality that governs whether or not they had the same incentive to litigate. And blanket applying burden of proof then opens the court to additional exposure for relitigating the same issue, which happened in this case.
But here we have more than just a differing burden of proof. I mean, we have a more developed record. We've got this additional, the dime examination.
At the subsequent hearing?
Right.
See, and I would
So
disagree.
why doesn't that inform the second ALJ's decision-making?
And I would fully disagree that we have a further developed record, and to the contrary, at the second hearing, although there may have been an additional medical report, the record as it pertains to the hearing was not developed further. There was no additional testimony. The judge at the first hearing had the opportunity to hear concessions made by the authorized provider. A division IME physician is bound and constrained by the 4 corners of a medical report of a prior physician. They don't hear what concessions were made at a hearing by an authorized provider, acknowledging that the elements and factors of the medical treatment guidelines for CRPS weren't met, and without an explanation as to why the medical treatment guidelines shouldn't apply to the knee. They don't have that. They don't have the order. They don't have the underlying deposition testimony. They don't have the transcript from the hearing. All that doctor gets are prior written reports, which are very limited and not detailed and not elaborated upon, and don't contain concessions that an administrative law judge considered at the first hearing. So for these reasons, it's clear that the burden of proof is not what should govern and carry the day. It sets back the purpose of issue preclusion. It delays the administration and issuance of benefits to claimants because it allows, conversely, if there was a finding of compensability and causality in an underlying hearing, and then the division IME says, with the law as it currently is, the division IME says that's not a related site of injury. If you have a claimant that is now on opioid medication for treatment for their back, and they've had a spinal cord stimulator, and they've had an H-wave system, and these things might require maintenance or future expenses for respondents that they were anticipating because of the establishment of causality, and the DIME says it's not related, now the claimant gets no opioid medications, no maintenance for their spinal cord stimulator. It completely contradicts the purpose of having final adjudication on issues before a merits judge, if the division IME doctor can overrule that.
I think your time's exhausted.
Yes, thank you.
May it please the court. My name is Aaron Kennedy of McDivitt Law Firm, attorney registration number 44094, and I represent the appellee in this matter, Mr. Owen Goff. This case primarily centers on the issue of issue preclusion in the workers' compensation realm. Mr. Goff respectfully requests that this court affirm the August 9th, 2017 order of the Industrial Claims Appeals Office. This order affirmed the findings of ALJ Spencer that issue preclusion did not apply at Mr. Goff's second hearing because the issues adjudicated at the second hearing were not identical to those at the first hearing before ALJ Walsh.
Can you, in your presentation, address the idea that there's no new medical evidence?
Yes, Judge, and that was specifically addressed in ALJ Spencer's order, as well as the Industrial Claims Appeals Office's review of the ALJ's order, and that's why they upheld his order based on the fact that he documented substantial evidence to evidence this change of condition. Some of those particular facts referenced were the fact that Mr. Goff's primary treating provider, Dr. Brunworth, responded to a letter after the first ALJ's hearing before ALJ Walsh, indicated that she felt more treatment should be offered for claimant. There were updated treatment notes from Dr. Brunworth, claimant's treating physician, in the roughly 1 year between hearings that documented additional medical findings consistent with CRPS, including increased swelling, redness, the hallmarks of a CRPS diagnosis. And 3, the DIMES evaluation and reasoning provided more information consistent with the finding of CRPS based on his evaluation, because as we know, medical conditions can be fluid, and especially with a condition of CRPS, which can fluctuate in terms of what symptoms are present at any given time.
So your position is that there was new medical evidence provided? As I understand, opposing counsel, all that was submitted was the medical reports.
I'm sorry, could you rephrase the question, Judge?
It's my understanding that opposing counsel says all that was submitted to the DIME physician was the same medical reports that were submitted to before, or that were before ALJ Walsh.
Well, I would disagree with that statement, Judge, in the fact that with the DIME, when that occurred, there were updated treatment records, but primarily it would be the DIME's examination itself that documented these specific hallmarks of a CRPS diagnosis, and it was ALJ Spencer's determination that these new findings amounted to a diagnosis of CRPS, and that's why he concluded as such, and that's why the ICAO confirmed that based on the substantial evidence standard, that essentially, as long as there is more than a mere scintilla of evidence to support a ALJ's decision, that that there should be deference given to the ALJ, and that should be supported.
Let me try to follow up Judge Marquez's question a little bit. You referred to updated treatment notes, I assume from the ATP.
That is correct.
And a post-hearing letter from the ATP that offered some different observations on this pain syndrome, correct?
That is correct.
Okay. Are either or both of those in the record for the second hearing?
I believe they are, Judge.
If not, were they specifically referred to in the DIME physician's report?
The DIME physician would have typically referred to everything that was sent to him. I cannot recall specifically whether or not that doctor referenced those specific reports in his report.
Fair enough, thank you.
So what claimant
Well,
is...
Let me stop you. Can we decide the case in your favor based just on what you said without even getting to this somewhat arcane legal question of whether different burdens of proof are part of the first element under Sunny Acres?
Well, I do think the differing burden of proof argument is pretty critical to this analysis, Judge.
Well, if the facts are different, if we start with the facts and the facts are different, then why is a different burden of proof necessary to avoid issue preclusion?
And I believe the reasoning for that is because there were two separate analyses regarding issue preclusion performed by the ICAO. One was whether or not the issue of whether or not claimant had CRPS could be relitigated, and the issue of whether or not the specific medical benefit of the lumbar sympathetic block could be relitigated. And I believe those have two different analyses as explained by the Industrial Claims Appeals Office. The standard of differing burdens of proof is supported by a myriad of cases offered by the ICAO interpreting this court's dicta from the Holnum case as it applies to the burden of proof issues created by DIMES. The holding in Holnum was related to claim preclusion Thus, there was no official holding regarding issue preclusion, but the court held that the new claim the claimant had filed was the same as the previous claim and thus barred litigation. Although the court did not have to address the issue of issue preclusion, as it was decided on claim preclusion, it went out of its way to provide guidance on this issue of issue preclusion. The court held that the differing burdens of proof did not matter for claim preclusion, but specifically stated, citing the restatement second of judgment, section 28.4, that issue preclusion may be affected by the burden of proof, a principle that does not translate to claim preclusion. The restatement second of judgments addresses exceptions to the general the general rule of issue preclusion, and specifically says that the issue preclusion should not apply if there's a significantly heavier burden a significantly heavier burden of proof involved, or if the burden of proof has shifted to the adversary. In this case, we have both. The burden of proof has shifted to appellants, as well as the fact that the burden of proof has increased to a clear and convincing evidence standard. This allocation of burden of proof and the standard of such burden are absolutely critical and often the deciding factor in which party prevails in any given case. Since the burden of proof is often outcome determinative, it is simply not just to say that the issue has already been adjudicated when the outcome is likely to change. That is not the spirit of issue preclusion. The facts of this case highlight the correct rationale discussed in Holnum in the persuasive restatement second of judgments. Moreover, it highlights that the intended purpose of the division independent medical examination in the workers' compensation system is working. That purpose is to have a truly independent physician make a determination regarding maximum medical improvement, causation, and impairment ratings. As ALJ Spencer indicated in his order, the statutory scheme essentially assigns ultimate responsibility for determinations of maximum medical improvement, causation, and impairment rating to physicians and not judges. The DIAM process makes questions of medical treatment and diagnoses more of a medical determination rather than a legal one. The statutory scheme of making maximum medical improvement and causation primarily a medical determination and changing the burden of proof resulted in the different outcome in this matter.
Can I ask you a question?
Of course, Judge.
If there were no new medical evidence, but the burden of proof then had changed, would the burden of proof alone preclude the use of issue preclusion?
Yes, Judge, and the reason for that would be simply because the outcome of the hearing is likely to change. I don't believe it can be rationally said that you have identical issues at one hearing versus a subsequent hearing when the burden of proof is on the opposite party because of the likely differing outcome. I mean, that just is not an identical issue.
Counsel, how do you respond to your opponent's contention that workers' compensation is special and therefore the differing burden of proof should not be dispositive in application of issue preclusion?
Well, I mean, I would disagree. The Sunny Acres Court made it pretty clear that all four prongs of the issue preclusion test must be met. And of course, the first prong is identical to, the first prong indicates that the issues must be identical to the issue actually determined in the prior proceeding. And for the reasons as I previously explained, because of the differing burdens of proof, the issues being presented to the subsequent ALJ would not be identical for that very reason. Now, with all due respect to ALJ Walsh at the initial proceeding, the overwhelming weight of the evidence supports a finding that Mr. Goff does have CRPS and requires medical treatment for his condition.
Well, how can we go there if the ALJ found the opposite?
Well, I understand, Judge, but I mean, that was based on the fact that virtually every physician of record except for respondent's retained expert has agreed that claimant has CRPS or requires additional treatment or diagnostic evaluation for this. So without this DIME process and the truly independent medical review, his case likely would have been closed. You know, that, Your Honors, is the purpose of the dime, to put the big medical questions in the hands of independent physicians, and thus why the legislature gave the dime physician special deference by applying a clear and convincing evidence standard when trying to overcome a dime's opinion regarding maximum medical improvement and causation, again referring to ALJ Spencer's interpretation of the statutory scheme that this is how the Workers' Compensation Act was set up, to allow physicians to make these big medical decisions as opposed simply to judges. Again, the first issue to be precluded was whether or not claimant has CRPS. The second issue was the specific medical benefit of the lumbar sympathetic block, which I believe we already talked about, and which was supported based on the substantial evidence as I cited previously. But this issue also brings into play the issue of issue preclusion, because at first blush, it would seem that the issues would be identical in the sense that Mr. Goff was seeking the same treatment. However, that's not the case because of the record that had been developed in the 12 months in between the different proceedings. So at this point in time, claimant simply requests that the this court affirm the August 9th, 2017 order from the Industrial Claims Appeals Office, both on the grounds that issue preclusion did not apply to the causation analysis at the second hearing. It did not apply to the analysis regarding the repeat lumbar sympathetic block, and that there was substantial evidence in the record to support the findings of ALJ Spencer at that subsequent hearing. And unless there are any other questions, that's all I have, Your Honors.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel in this case are excused. When the tables are cleared, we will take up our last case, which is Turner v. ICAO. Gentlemen, unless either of you has questions, we're ready to go when you are.
Save the best for last, Judge.
Your call.
May it please the court, my name is Steve York. My attorney registration is 19418. My law firm is Dworkin Chambers and Williams. I represent Donald Turner, the claimant and appellant in this matter. Before I start, I want to thank the panel and the Court of Appeals staff for allowing us the opportunity to argue this very interesting case to you. And personally, thank you for accommodating my quirky schedule as it happened back in March and April of this year, and allowing us to go forward today. Mr. Turner is an over-the-road trucker for respondent. He was injured in the state of Colorado delivering a load of lumber from for his employer in Canada to Henderson, Colorado. He filed a claim for workers' compensation. A hearing was held, and Magistrate Felter ruled that there was no jurisdiction as there was not substantial employment in the state of Colorado. In so ruling, ALJ Felter looked at the quantum of evidence and came up with various percentages and numeric values and found that there was not regular and routine operations by the employer, by the claimant for the employer in the state of Colorado, as those operations were compared to other states, namely California. The court found that because states like California, Montana, Utah had a greater percentage of work where the claimant worked more days, traveled more miles, worked more hours, you can't have substantial employment here in the state of Colorado. We have two issues with that. The first issue is Colorado precedent makes very clear that the mere fact that the majority of the claimant's work for the employer is in another state does not deprive this court or Colorado of jurisdiction. In the HEP case, Colorado Supreme Court, Home Insurance Company versus HEP, it's 15P2D 1082, Colo 1932, the court found that the claimant was an insurance agent for home insurance in New Mexico. His office and his place of employment, his office and his residence were in the state of New Mexico. And the major portion of his work was in the state of New Mexico. Despite that, the court found jurisdiction. Likewise, in the Colorado Supreme Court case Fidelity, let me give you the full site, United States Fidelity and Guarantee versus the Industrial Commission, 61 P2D 1033, Colo 1936, despite finding that a major portion of the work by the claimant for the employer was in the state of Texas, jurisdiction still attached in Colorado. Likewise, in a more recent case, the Court of Appeals case, Monolith, Portland Cement versus Burack, 772 P2D 688, Colorado Court of Appeals, 1989, the Court of Appeals found that despite the fact that the claimant who lived in northern Colorado commuted to Wyoming for work, despite that, the court found jurisdiction in the state of Colorado because there was competent evidence that the claimant did work at home. His wife and his kids testified that he often worked after hours at home. The court found, despite despite the fact that the majority of work was in the state of Wyoming, the court still found jurisdiction. So that's the first thing that we have a problem with. The fact that Mr. Turner might have driven more miles in the state of California, worked more days in the state of California, does not deprive this court of jurisdiction, does not deprive this court of the ability to find the regularness and routineness of work here in Colorado.
So is it, articulate as precisely as you can what test we should apply in deciding this case. You're talking about, you apparently disagree that it's quantitative. So exactly what test should we apply, and what's the basis for that test in statute, Colorado case, or something
Thank you.
else?
That's an excellent question. That brings me to my second problem, or the second problem we have, and that is the percentages do not tell the story.
I take it you don't quarrel with the percentages as a matter of evidence.
I do not. I do not. And, you know, let me just state, be as transparent as possible, we don't quarrel with any of the evidence that was submitted in this case. Our quarrel was that the court misapplied the test. The test that should be applied is that the Court of Appeals and the ALJ and the panel and the Supreme Court should look at what the employee was doing in the state.
But not quantitatively.
Correct. Correct.
Well,
I'll give you an example, Your Honor. The HEP case. In the HEP case, the court found that the claimant made several trips to Colorado. And the court looked at it, the court drilled down and said, what are the duties? What duties did the claimant perform in the state? And in the HEP case, the court said, he went to Trinidad, He inspected risks. He even inspected a risk in a place called Starkville in Colorado. And the court looked at that very carefully. Likewise, in the Fidelity case, the court looked at the duties that were performed by the claimant for the employer. In that case, the court said that the claimant, under his contract with the employer, was assigned to drill a well in Colorado. So his duties involved drilling a well in Colorado. But the most important case is the Supreme Court case in the RCS Lumber. I'll get you the site for that.
Well, that's in the brief, so you don't have.
Okay, RCS Lumber versus W.G. Worthy. And in that case, the court denied jurisdiction. The court denied jurisdiction. The court found that there was no evidence that the claimant was performing any work as an edger. The claimant was an edger for a sawmill in New Mexico. And the court said he was performing no work as an edger when he went with his brother to Colorado to deliver a load of lumber. And I'll quote the court. The court says, "There is no competent evidence, however, that his duties at the sawmill had varied so often as to make such trip part of his regular employment." So the court focused on the duties there. And the quote even put in quotations, regular employment. So where we find that...
Okay, let me try to get to the
Sure.
bottom line here.
Yeah.
So is it your position that if the injured worker is performing the duties for which he is paid, whether he's in Colorado 1 day a month or 1 hour a month or 10 days a month, doesn't matter?
That's correct. That's correct, Your Honor. And that's, and the reason...
Well, I guess, how is that a helpful test, though? Because there wouldn't be comp coverage in the first place unless the injury occurred in I can't exact phrase, but in the nature and course of the duties. So, I mean, it seems to me duties are a condition precedent to any comp coverage jurisdiction question. So if any duty, doesn't it become a tail-chasing kind of exercise? If any duties, no matter how slight, create jurisdiction?
No, I don't think so. I think it's usually, I think two things. It's usually a two-prong analysis. The first thing the court's going to do is determine whether there's jurisdiction. And then they're going to move and make a determination like they did in Fidelity and HEP, whether or not and in the Perryman case, whether or not that person was operating and doing work that was in the normal course and scope of the business. The second thing is in RCS, the RCS Supreme Court case, the court said, the court looked at it because it was a one-day trip to Colorado to deliver lumber. And instead of saying, that's a one-day trip to Colorado, let me back up, because I have it, I wrote it down because I think it's important. I said, why would the court look to see if there was evidence of the claimant's duties in the RCS case, when the court could have said, no matter his duties, it was just a one-day trip, a micro percentage of his work in Colorado. And that's what we think is the error, because the panel affirmed, and the panel said, we're relying upon RCS, because in RCS, the court on a one-day trip denied jurisdiction. But that's not why the court denied jurisdiction. The court denied jurisdiction because the claimant was not performing his duties as an edger. He was simply unloading lumber. And that's exactly what the court found. And the court, starting with the panel, starting the Industrial Claims Appeals Office, starting with the Richardson case, they've gone astray by looking at the RCS case and saying, oh, one day, that's not enough. One strike, you're out.
Counsel, but in RCS, the court also looked at, has the claimant shown that a substantial portion of his or her work was performed in Colorado? And it also said that that very question is a question of fact for the ALJ to determine. I mean, aren't you effectively asking us to second guess what the ALJ factually determined?
No, Your Honor. I think, as we argued to the ICAO, the panel, we said the court misapplied that test. We're not arguing with the facts. We're saying that the test was improperly applied and that under Colorado law.
But then what does substantial portion mean? I mean, what are you saying that means?
I'm saying a substantial portion means if it's fortuitous, if it's a ride-share arrangement, like in the Laughlin case, then there's no jurisdiction. But if you're going to Colorado to drill one well, then it's because you're doing your employer's duties, then it's jurisdiction. If you're going to Colorado to do a risk assessment, like as in the HEP case, then there's jurisdiction. If you're working at home, at night, after dinner, after your kids have gone to bed, as in the Monmouth case, there is enough jurisdiction. There's enough, that's substantial employment to find jurisdiction.
It sounds like your test is, if you're doing your duty, it doesn't matter what amount, that somehow equals substantial portion? I don't understand that.
That's right, Your Honor, because otherwise, I mean, if the test is, you have a percentage, then how can this court, or how can the panel ever look at it and say, that's wrong? Because it's always be a factual determination. Well, they found that 2% wasn't enough. They found that 10% wasn't enough. They found that 15% wasn't enough. Under the HEP case, the court said it has to be indefinite and indeterminate in order to make a substantive decision. Otherwise, if you're counting hours and numbers, for example, if you're looking at miles, and one of the trips is in Rhode Island versus California, how do you look at miles and make that determination? And it's not fair. It's an arbitrary. Looking at percentages can create an arbitrary finding. So if you're doing your work in Colorado and you're assigned to do the work in Colorado and you're injured in Colorado, unlike the Perryman case where he was injured in Kansas, then jurisdiction attaches.
No matter how slight would be the various percentage analysis.
If you're doing your duties, yes. Unlike in the Laughlin case where you're doing a ride-share arrangement to and from work, the court found that doesn't apply. The jurisdiction does not apply because it's fortuitous. In the Youngquist case that counsel was involved in, the court said, look, a mere phone call to Colorado isn't enough. Because the contract wasn't entered into there. So, but if you're doing work.
What you're saying is if you make the phone call from Colorado, that's enough.
If it's part of the normal, routine, and regular operations of the employer, then yes. If you're directed and assigned to do work in Colorado by your employer and you're hurt in Colorado, then that is the test. And it should be that simple. Thank you.
He's all right. May it please the court, my name is J.B. Fairbanks with Trees Hall Free MUSAC. Thank you, counsel, as well. I represent the employer in this case, a Canadian employer. It's a workers' compensation case, but I think, as indicated from claimant's counsel's argument, it's also a jurisdiction case. We would submit that the agreement today by claimant's counsel that he's not arguing anything regarding the facts, which is also mentioned in our particular brief, notes that there is substantial evidence for the factual finding in this case that there is no jurisdiction. And in light of that, unless there was some sort of legal error, which I don't believe the claimant can demonstrate, then the order below should be affirmed of ALJ Felter, and the Industrial Claims Appeals Office has already affirmed that, saying the factual findings should not be disturbed upon appeal. Basically, I think the essence of counsel's argument today was to retry the case and apply a standard that I will admit I'm unsure exactly what standard that would be.
Well, what about his argument, though, that one ALJ may say, let's just take an over-the-road truck driver, one ALJ may say 20% of the total year's miles in Colorado isn't enough, and the next ALJ may say, well, 20% would be enough, but 15% wouldn't. I mean, doesn't looking at the percentages without some controlling standard permit an enormous variety of outcomes as people do the calculation.
And sure, as an overview of that response, I'd say we do get an enormous variety of factual outcomes to cases, especially in workers' compensation. We get it in determining average weekly wage. That's a financial calculation. We get it in determining whether a person gets an amount of benefits for a certain amount of time. We get factual arguments where there are defenses. The case that was just argued prior to you had two different factual outcomes based upon an interpretation of a judge.
Well,
We
my
get these
question
things all.
may have been ill-framed. I'm saying the present state of the law would seem to me that in one case, an ALJ can say 20% of the over-the-road truck drivers' miles in Colorado is substantial, and in the next case, the ALJ could say 20% isn't substantial. So shouldn't we be concerned about that variability and try to address it?
I don't know if we'd be concerned about the variability because there's no strict formula. That's what the case law says. And I don't even know what counsel's alternative test is. Putting aside for a moment the fact that they argued mathematical formulas below, I mean, that's in the record. They had their own interpretation of how much. The Richardson ICAP case is a percentage case. The RCS Lumber mentioned the one particular case was not enough. These are variable determinations. That's why we have substantial as the qualifier.
And
This
what's your position about what that means? What does substantial portion mean
It
in
means
this
it's a factual
context?
determination by the ALJ, Your Honor. If we didn't use percentages, I don't know what we would do. He basically argued, counsel argued that if they drove into the state of Colorado, that's jurisdiction. That's the essence of his argument. He was kind enough to reference Youngquist, which is a minimum contacts personal jurisdiction case, which I was involved in. And in that case, we successfully argued to the Colorado Supreme Court that one phone call was not enough to establish personal jurisdiction. That's sort of the underpinning of the statute itself. There's got to be enough context. That's the personal jurisdiction. Then you read that in context with the statute itself, and substantial employment is what the ALJ says it is. And in this case, they're just unhappy with the result. There was no legal error by Judge Felter here. He applied the case law appropriately. And I don't know where there's a standard for I think they said in their brief, call it the substantial portion test. I don't know what that means, Your Honor.
So your test is whatever the ALJ says?
Sure, and it's substantial employment if it's supported by the reasonable amount of facts and by the substantial evidence. There's that word again, substantial. That's what we use in the Workers' Compensation Act. If there's substantial evidence to support the factual finding, then it's appropriately applied by the administrative law judge. He's just using the statute, and 841-204 says hired or regularly employed. So the idea was somebody, in this case, Mr. Turner, drove 40 different states and provinces. He just happened to have his incident in Colorado is what happened. You still have to prove substantial portion of that employment occurred in Colorado. From a percentage standpoint, even under their argument, it came out to 6%, which the judge said is still insubstantial. That's one of the findings of fact of ALJ Felter. Our argument was it was a little bit less than that, and he said no matter which way you slice it, there's still not substantial employment here.
So what if this truck driver, spent the same number of days or hours in Colorado, but it was his company's most significant contract? Could he satisfy the substantial portion by virtue of the magnitude of the business relationship with Colorado?
Oh, I don't see why not. I mean, it could be in certain circumstances, sure. It's going to depend on what that argument of what substantial employment is. If you go look at the record on this case, you look at the case law, you look at U.S. Fidelity, you look at Youngquist, all these cases involving in jurisdiction is it fair to sort of bring this employer in? And I might remind the court on this issue too, we have a Canadian employee, Mr. Turner, who received Canadian workers' compensation benefits, then hired an attorney in Colorado almost 2 years later to file a Colorado workers' compensation jurisdiction claim against a Canadian employer whom I represent. Not only that, he asked for penalties against my employer for not having insurance in the state of Colorado. The administrative law factually did the right thing here, and also public policy did the right thing in this case. This particular over-the-road truck driver drove in 40 different states and provinces. There was more time spent in California. There was more time spent in other cases. There was less time spent in other cases, or other states, sorry about that. So in this particular case, he just happened to find under both positions that the quantitative amount was support for his order that the employment was not regular and routine in the state of Colorado. I think that's totally appropriate. And I think if you had a case where somebody came in, I think somebody said 20% earlier, I think that's a much better argument than 3.25 to 6.2%. He just found that, and it was very similar to the Richardson case, which is the ICAP case, which is certainly not direct authority for you, but it shows you the way the workers' compensation system works below. And we have all these quantitative analyses which are necessarily part of it. The flip side of that, if you accept the counsel's argument, is what's a qualitative test? Just whatever the claimant attorney says it is? Hey, you know what? They purposely went into the state of Colorado. Well, sure they did. He was driving a truck. That doesn't mean you're complying with 841-204, which says hired or regularly employed. It's clear he wasn't hired here. But regular employment is key. And the case law and the statute has been interpreted over a number of years. It's just there's asking to sort of rewrite the interpretation in a way that factually submits their argument in this case. There's no real test they're proposing. And I don't know where you're restricted from using quantitative analysis. I think judges use it in jury instructions. I think I've seen courts in other situations. Here's an order for a domestic relations order. Well, you know what? In this case, I find that a substantial amount of the income was earned by this particular individual. You know what it's based on? Wages. It's based on other figures. I don't think anything precludes the court below, especially Administrative Law Judge Felter, from utilizing quantitative methods. I think we're just parsing issues here to sort of argue a result that factually they disagree with. And as acknowledged by counsel in this particular case, they don't have a qualm with the facts. Their best case scenario was 6.2%, so I think they're arguing some sort of bright line rule. I don't know what that is other than, as advanced by counsel here today, as soon as you purposely go into that state, there's jurisdiction. The Youngquist case certainly says no on a personal jurisdiction level. This one is more of a subject matter jurisdiction, but I think the policies are sort of the same. It's whether or not it's fair for my Canadian employer to come in to this particular state unless they had done substantial employment. I think if you look at the record on this case, there's a number of figures that are involved, figures argued by both sides, that would support his finding that there is substantial employment. And I don't think there's a legal error, at least advanced in the brief or an oral argument by counsel, that I could point to say there would be an alternate outcome. In this particular case, ALJ Felter looked at their argument and discarded it. They also argued from a public policy standpoint, somewhat similar to what they did today, that since we go into this state, we're subject to jurisdiction. I would say that can't possibly be the test, and I would say it's not the test. So,
Under your test, as I understand it, if this ALJ had said that the percentages that were found here, even 6.2, were substantial, you would have no argument with that.
I probably wouldn't, Your Honor, because I don't know how to overturn that factually, because I wouldn't be able to. I'd be unhappy with that result, such as the claimant is here, but I would probably have to accept that unless there was something egregious. Let's say there was 0.1%. I might say that's an abuse of discretion. Or I might come to this court and seek relief on reviewing this de novo. This can't possibly be correct. But if the case had come out, let's say there was, I'm just going to throw out a number that doesn't mean anything really, 67% of my time was in Colorado, I probably wouldn't have even argued this case, because that would, by definition, be something this court could review for that issue. Here you're talking about minute percentages, and I think Judge Felter, the ALJ below, and ICAO both sort of addressed that situation. He reviewed it. He made a determination that the employment was not substantial, and that's what he's permitted to do under the statute. And it's really not my test so much on it. It's more like how the case law and the statute has evolved over time. Workers' compensation can be difficult. Jurisdiction issues can be difficult. That's why I submit quantitative method actually helps the trier of fact here. And I think one of your questions to counsel was especially instructive, like, what else would we do? What else should the judge do? I don't know. I can't think of something other than you could make sort of intangible arguments like the Canadian truck driver was in this state a lot, and he did a lot for the company. He had relationships with the company. I'm just trying to even sort of advance an idea where you may have something intangible that could be considered. And I think if you look at the factual portion of his order, he does consider that. He mentions the fact that it is undisputed he was employed by employer from 2012 to December 2013. He was an over-the-road truck driver for all periods relevant. He would travel from British Columbia to a variety of destinations, including Colorado. That's what he was. That's the testimony was. He was an over-the-road truck driver. I don't think he did anything unique other than he took loads to various states and he dropped them off, and then he would stay there for a little bit. And I think there is, you can always interpret factual evidence in different ways. I've been upset with a lot of orders, even from Judge Felter, on how he interprets a statute. For example, the permanent total disability statute says, wages in the same or other employment. The statute you guys were dealing with earlier today, the clear and convincing evidence standard, I think that should be interpreted differently myself, and I'm sometimes unhappy with factual outcomes. And in this case, I think the essence of the argument is claimant is unhappy with the fact that they didn't receive additional benefits in Colorado in addition to their Canadian benefits, and from a jurisdiction standpoint, they think that this court should somehow apply an alternate test that would be facts-based outcome in this case when they didn't like how the facts came out in their favor, or not in their favor in this case. So. And if there are no other further questions from the distinguished judges, then I would yield the rest of my time.
Thank you. Thank you. Just briefly, I think, Judge Fox, you hit it on the head. You know, is the appellee really arguing that their numerous trips to Colorado to supply Home Depot is insubstantial, is not substantial? Home Depot is a national chain in this country. You know, and with that, I'll say, look, if numbers and calculations and percentages carried the day, the claimants in HEP and Fidelity would have been denied Colorado workers' comp benefits. If numbers and calculations and percentages carried the day, the court in RCS would have said, one trip to Colorado, one strike, you're out. And that's not what the court said. Thank you.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel are excused. We have nothing else on the docket. The bailiff may announce a recess.